Oakland County prosecutor Karen McDonald, who helped convict the parents of Ethan Crumbley following the Oxford High School mass shooting there. When Colin Gray was charged last night in connection with his son's alleged shooting in Georgia, it marked the second time, and only the second time, that the parents of a suspected shooter had been charged. You led the prosecution against James and Jennifer Crumbley, which took months and months to do. What was your reaction when hearing that the suspected shooter's dad was charged within 24 hours?
You know, I had the same reaction that so many of the victims from Oxford did, which is the horror that that's just playing out again, and so senseless, just so senseless when it's just so easy to secure your firearm.
And yet the fact that the charges came so quickly after the event, what does that tell you as a prosecutor?
You know, our case was prosecuted under a gross negligence, involuntary manslaughter standard, not for what. Not holding parents accountable for what their son did, but holding them accountable for their own gross negligence, which was criminal.
No sins of the son charge here. Yeah, but let's lay out some of the charges, because they do mirror in somewhat yours. Colin Gray last night was charged with 4 counts of involuntary manslaughter, 2 counts of second-degree murder, and then 8 counts of cruelty to children. Colin Gray, if convicted, could face a total sentence of up to 180 years in prison. So those 4 involuntary manslaughter charges mirror the ones that you had against the Crumbleys. But tell us a little bit more about the second-degree murder and the 8 counts of cruelty to children. Those, I know state laws are different and different prosecutorial jurisdictions are different, but what does that tell you about this case and how it differs from yours?
You're absolutely right that the Georgia criminal statutes are not identical to the Michigans, and I'm not licensed in Georgia. So it appears that there is a second-degree murder charge available when it's a violence and the crime is a child. So that seems to account for the second degree. But look, these are difficult cases to charge and really difficult cases to convict on, and it should be very hard, because holding a parent responsible criminally in a school shooting related to one should be rare.
Right.
And in our case, the facts were very rare
and
egregious.
And so in this particular case, some of the facts have spilled out into the public domain. We know that law enforcement had questions for Colin Gray over his son's firearms and his son's behavior more than a year before the shooting, in May of the previous year. And the father told investigators that he bought the gun in December for his son. Does that make it hard for the father to argue against that gross negligence clause that you were trying the Crumbleys for?
I think it makes it difficult to argue that there wasn't any foreseeability that there was an issue when law enforcement visited your home a year prior and asked if your firearm was secure and if your son had access to it because of an allegation that he made a threat. That's a pretty direct evidence of you were sort of on notice. But again, I'm sure there's a lot of other evidence that has not been released. For instance,
Sure.
we don't know at this point if the gun was secure or how it was secure or in what capacity the minor had access to it and what kinds of signs he might have been showing. We just don't know that.
Sure. Your case, in many ways, was seen as an anomaly. Do you think this is a new shift in legal thinking? Is this going to be a legal trend?
You know, I always resisted the idea that this sets some precedent, because I just firmly and wholeheartedly hoped that we wouldn't have a set of facts that would give rise to such a charge and conviction. When, again, I'm going back to the idea that it takes less than 10 seconds to install a cable lock on a firearm. All responsible gun owners will tell you that your weapon should be secure. At the end of the closing argument in James Crumbley's trial, I actually installed a cable lock and showed the jury, and it took around 10 seconds. And I installed it on the murder weapon. So this is so senseless and so tragic when we know it is so easy to prevent. It is so easy to prevent.
Karen McDonald.
But not just one of these facts leads to a conviction. There has to be a lot of evidence taken as a whole to meet your burden of proof.
A very compelling argument indeed. Thank you, Oakland County Prosecutor Karen McDonald. Thanks for joining us.
Thank you.